Good morning, ladies and gentlemen. I'd like to welcome you to County Court at Law Number 2. My name is Judge Terrence L. Holmes, and I'm the presiding judge here in County Court at Law Number 2. You have been asked to come to court today for what is called an arraignment. And what the arraignment is, it's an opportunity for the court to tell you what you've been charged with, what your rights are, and what your options are concerning your case. The case that you have in this court is a criminal case. It's a misdemeanor criminal case. Criminal cases are divided into felonies and misdemeanors. Your felony cases are commonly referred to as your most serious type of offenses, whereas your misdemeanor offenses are normally referred to as petty offenses. Does not mean that they're not serious. It just means that they're not as serious as a felony offense. And when I use the term serious, what I'm talking about the facts of the case and the possible punishment that a person can receive if they're convicted of the offense. Now, if you had a felony case, your felony cases are divided into 5 categories. We'll start at the top and work our way on down to the bottom. And you have the capital murder, first-degree felony, second-degree felony, and the third-degree felony, and the state jail felony. If a person is convicted of a state jail felony, the range of punishment is minimum 6 months to a maximum of 2 years in the state jail, and a fine that does not exceed $10,000. If a person is convicted of a third-degree felony, the range of punishment is minimum 2 years to a maximum of 10 years. If a person, and a fine that does not exceed $10,000. If a person is convicted of the next highest felony, which is a second-degree felony, the range of punishment is minimum 2 years to maximum 20 years in the state penitentiary, and a fine that does not exceed $10,000. If a person is convicted of a first-degree felony, the range of punishment is minimum 5 years to a maximum of 99 years to life in the state penitentiary, and a fine that does not exceed $10,000. Now, if a person is convicted of the highest felony, which is a capital murder, the range of punishment is minimum life in the state penitentiary without the possibility of parole or death by lethal injection. Now, you don't have to worry about that because, as I mentioned to you earlier, your case is a misdemeanor case. Misdemeanors are divided into 3 categories. We'll start at the top, work our way on down to the bottom. You have the Class A misdemeanor, the Class B misdemeanor, and the Class C misdemeanor. Now, your Class C misdemeanors are cases that normally start or originate in the city court or the JP court, for example, speeding or not having your seatbelt on or having an expired sticker. Those are Class C misdemeanors. Now, they come to this court when a person is found guilty in that court and they appeal the case, then it comes here. And when it comes here, you get a whole new trial. The range of punishment does not change. And the range of punishment is fine only. You can't be given jail time. You only can be given a fine up to $500, $0 to $500. Now, if you fail to pay the fine, or if your fine was converted to community service and you fail to perform the community service, then the court can issue what is called a capious pro fine. That simply means it's a warrant for your arrest to pay the fine or sit the fine out. Now, if, and then you'll receive $100 per day that will be credited toward your fine and court costs. Now, the next highest misdemeanor is a Class B misdemeanor. The range of punishment for a Class B misdemeanor is minimum 0 days to a maximum of 180 days in the county jail, not the state jail. A fine that does not exceed $2,000, or you could be given both such fine and confinement. She needs a now, the next highest felony, next highest misdemeanor is a Class A misdemeanor. It is the highest misdemeanor. The range of punishment is minimum 0 days to maximum 365 days, which is a year in the county jail. A fine that does not exceed $4,000, or you could be given both such fine and confinement. Now, excuse me. As a defendant in a criminal case, you have rights. One of the rights that you have is the right to have an attorney. That clipboard that you have, I will go over the rights that you have. It's your right to have an attorney. And basically, the first document is the judge's explanation of rights to defendants without attorney. And it states that as a defendant in a criminal case, you have 3 options regarding your right to have an attorney. Number 1. Now, what I need everyone to do is make sure that you're looking at the same page that I'm going over, because I'm going to go over that page with you. Okay, so that's the judge's explanation of rights to defendants without attorney. Now, under the title, it says, as a defendant in a criminal case, you have 3 options. Number 1, you may hire an attorney. Number 2, if you do not have enough money to hire an attorney, you may request that an attorney be appointed to represent you. Or number 3, you may represent yourself. Now, if you have enough money to hire an attorney, you would like to hire an attorney, your case will be reset. Reset means that you'll be given another court date to give you time to hire your attorney. Now, if you want an attorney, but you do not have enough money to hire an attorney, you may request that an attorney be appointed to represent you. But you must first fill out a financial questionnaire. The financial questionnaire is also on that clipboard. It's titled Jefferson County Affidavit of Indigence. And basically, when you look at that document, you're going to fill out the first page and half of the second page. Now, if you desire to represent yourself, that is, you want to represent yourself and you do not want an attorney to represent you, you must first fill out a waiver. The waiver is also on the clipboard. Now, you only fill out the waiver. It's titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. You only fill out that document if you're giving up your right to have an attorney and you want to represent yourself. If you're not doing that, you don't need to read and sign that document, okay? So let me explain this to you again. If you want to hire an attorney, you're going to fill out, you're going to sign the document that is titled Judge's Explanation of Rights to Defendants Without an Attorney. Right. If you want to apply for a court-appointed attorney, you also will fill out the Judge's Explanation of Rights to Defendants Without an Attorney and the Jefferson County Affidavit of Indigence. Now, the third thing, if you would like to represent yourself, then you will fill out also the Judge's Explanation of Rights to Defendants Without an Attorney and the Waiver of Counsel for Purposes of Entering a Guilty Plea. All right. Now, at the bottom of that document, you'll see a paragraph. It's the second to the last paragraph. It says basically that you should be advised or you should be aware that there are dangers and disadvantages to self-representation. Waiving your right to an attorney and representing yourself may result in a worse outcome for you and your case, including the loss of significant rights and opportunities relating to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. In the last sentence, it says that before we get down to the bottom, it says, if you desire to represent yourself, you may change your mind at any time and request that an attorney be appointed to represent you. Now, for those of you who be waiving your right to an attorney and representing yourself, you will have an opportunity to talk to one of the prosecutors that's in court. They're sitting at the table before you. They work for the Jefferson County District Attorney's Office. They are assistant criminal district attorneys. Now, you can talk to them only if you waive your right to have an attorney. Why? Because at that point, you are your attorney. You will be representing yourself. Do you understand? All right. Now at the bottom of the very bottom of that first document, in bold letters, it says defendant's choice. Mark initials next to only one choice. If your choice is to waive your right, well, if your choice is to hire your own attorney, then you will place your initials on the first line to the left. If you have already hired an attorney to represent you, you'll place your initials on the second line to the left and the name of the attorney on the line to the right. If you would like to apply for a court-appointed attorney, then you'll place your initials on the third line to the left. If you have already been appointed a court-appointed attorney to represent you in this case, then you'll place your initials on the fourth line to the left and the name of the attorney on the line to the right. If your choice is to waive your right to an attorney, that is to give up your right to have an attorney and represent yourself, then you'll place your initials on the fifth line to the left. Once you have finished initialing one of the 5 lines, then you will sign your name at the very bottom of that document where it says defendant, and you will date it today's date, September 10th of 2024. Now, for those individuals who will be representing themselves, as I mentioned to you earlier, you will also have to sign a document that is titled Waiver of Counsel for purposes of proceeding to trial. Let's see, it's titled Waiver of Counsel for purposes of entering a plea or proceeding to trial. And that document states that I have been advised of the nature and charges against me. So I know you're saying that you know what you have been charged with, and the dangers and disadvantages of self-representation. My waiver is voluntary, which means that no one is forcing me to enter into this waiver. I'm doing it on my own free will, and it's intelligently made, meaning that you know what you're doing. Furthermore, I have been advised this 10th day of September of 2024 by the County Court of Law number 2 of my right to representation by counsel in the case pending against me. I have been further advised that if I'm unable to afford counsel, one will be appointed for me free of charge. Understanding my right to have counsel appointed for me free of charge, if I'm not financially able to afford counsel, I wish to waive that right or give up that right and request that the court proceed with my case without an attorney being appointed for me. I hereby waive my right to counsel. And if that is your choice, that's only for individuals who are waiving their right to an attorney. You'd have to read and sign that document. You sign on the line that's titled defendant, and you would date it today's date on the line that's titled date. Now, for those individuals who are requesting a court-appointed attorney, you'll have to sign that Jefferson County affidavit of injuries. And that document, it asks for your name, date of birth, address, phone numbers, work, family members. It also, if you receive any type of benefits, Medicaid, SSI, SNAP, TANF for public housing, if you're receiving them, you check the box that applies. Now, if you are employed, you check yes. If you're not, it's no. If you're employed, you're gonna state where you're employed. That's the name of the employer, how, what type of work, the number of hours you work a week, and how long have you worked at this job. Now, it also asks for your marital status, whether you're single, married, divorced, widowed, or separated. You're gonna check one of those boxes. If you're married, you're going to write down your spouse's name. Now, if you have any children, 18 years old and younger, you're gonna write their names on and age on each one of those lines. At the bottom of this document, where it says residential information, if you are renting, you have to circle one, whether or not you're renting, you own, you reside with a family member, or you're homeless. Just answer those questions. Now, at the bottom left of this document, it says monthly income and assets. My take, if you're working, you're gonna put your monthly take-home pay. Now, if you're not working, it's gonna be zero. If you have a spouse that's working, you put your spouse monthly working. So you're gonna fill out each one. If you get food stamps, or if you get child support, or SSI, or any type of governmental benefits, you're going to put it in on those lines, and then you're going to total that amount. On the other side, where it says monthly expenses, if you're paying rent, or if you're paying a mortgage, or if you're not paying rent or mortgage, put zero. If you have utilities, light, gas, water, you're gonna put that amount. Child expenses, now the child expenses is if you receive child support and if you're doing other things for your child or children. And your food expenses, that's the food expenses in the household. Transportation, now transportation, what we're looking for is the amount that each month that you pay for fuel, your if you're paying a car note, and if you're paying car insurance. You're gonna total that and put it on the transportation cost. If you have a home or cell phone or boat, you put how much you're paying a month on that. If you're paying probation fees or parole fees, or even a bondsman, I'll put it right there where it says probation fees and the bondsman, you're gonna put it there. Now, if you have any health expenses or health insurance, you're gonna put on how much a month, and then if you have a credit card, what's the minimum payment? And then you're gonna total that up. And then once you turn to the second page, at the top where it says defendant's oath, you're gonna put the day's date, you're gonna read that, and then you'll sign your name and date it. And then you go to the bottom of the document where it says unsworn declaration, you'll fill that out, and that's it. Now, as a defendant in a criminal case, you also have a right to have a trial by jury. That area over there, we call it the jury box. 6 citizens from Jefferson County will be selected as jurors in your case. They will listen to the evidence, listen to all the arguments, and then they'll decide after deliberating whether to find you not guilty or guilty. You also have a right to waive or give up your right to have a jury trial. Yes, you don't have to have a jury trial if you don't want to have a jury trial. We call that a waiver. You're waiving your right to a jury trial. Next, if you waive your right to have a jury trial, your case will come before this court in one of 3 ways. It can come before the court by way of what we call a bench trial. A bench trial means a trial by judge only. The judge will be the judge and the jury in the case. The judge will listen to all the evidence, listen to the arguments. The judge will apply the facts to the law and decide whether to find you not guilty or guilty. Now, the other way that your case can come before the judge is by way of a plea bargain. That is, if you want to settle your case, that's what a plea bargain is, a settlement. You can talk to the prosecutor, or if you have an attorney, your attorney can talk to the prosecutor to see if they can settle your case. If you are able to settle the case, we call that an agreed plea bargain. Now, if you still want to plead either guilty or no contest, but you have not been able to reach a settlement, you want the judge to decide, we call that an unagreed plea bargain agreement. Now, with an unagreed plea bargain agreement, it basically means you don't have an agreement with the state. And so the judge will decide what the punishment will be within the punishment range. Now, if you have an agreed plea bargain agreement, it will come before the judge, and the judge could do one or two things. The judge could either will either accept or reject your plea bargain agreement. If the judge accepts the plea bargain agreement, then if you decide within 30 days that you would like to appeal the case, then you have to get permission from the judge. And if the judge gives you permission to appeal the case, then the case will leave this court and go to another court. Excuse me. Now, the court that it will go to, it will go upstairs to the Ninth Court of Appeals for them to review. They can either grant or deny your appeal. If they grant your appeal, then they could simply find you not guilty, or they could send the case back down to this court and order this court to give you a whole new trial. If they deny your appeal, you can appeal it to a higher court than them. You can appeal it to the Texas Court of Criminal Appeals, which is located in Austin, Texas. You would have to file what is called a pro se petition for discretionary review. Now, a pro se petition for discretionary review basically means that you are asking the Texas Court of Criminal Appeals located in Austin, Texas to review your case. And pro se means that you'll be representing yourself. They'll review your case. They could either grant or deny your petition. If they grant your petition, they could simply find you not guilty, or they could send it to the Ninth Court of Appeals with orders, or they could send it back down to this court with orders and give you a new trial. Also, now, if they deny your petition for discretionary review, at that point, your conviction will stand. Now, as a defendant in a criminal case, as I mentioned to you earlier, if your case can come before the judge by way of an agreed plea bargain agreement or unagreed plea bargain agreement. Now, if it's agreed, if the judge rejects your plea bargain agreement, then you could simply take your plea back. You can say, well, judge, since you're not following my agreement that I made with the state, I take my plea back. You have a right to do that if the judge doesn't follow the agreement. All right. Now, you also have a right to have witnesses to come to court. And witnesses sit in that chair with a microphone, as we call that the witness stand. They can testify. They can testify for you or against you. If you represent yourself, you could ask some questions. If your attorney is representing you, your attorney could ask some questions. We either call it direct examination or cross-examination. Now, you can waive or give up your right to have witnesses to come to court as well. Now, if you waive or give up your right to have witnesses, that simply means that you will not be calling witnesses. It does not mean that the state will not be calling witnesses, because the state will be calling witnesses. Now, you also have what is called a Fifth Amendment right against self-incrimination. And I know some of us, we watch television and we see some of these law programs on television. You hear somebody say, I take the fifth. Well, that means I ain't saying nothing. Okay, you have a Fifth Amendment right against self-incrimination, not to testify in your case. The state of Texas, the DA's office, the government, nobody can force you to take the witness stand if you exercise your Fifth Amendment right against self-incrimination. Okay? Now, the other thing is you can waive or give up your Fifth Amendment right against self-incrimination. And by doing so, you will be taking the witness stand. Also, you also have a right to have what is called discovery. Discovery means you have a right to see the evidence. That is, you have a right to see the evidence that the state has in their file, the evidence that they'll be using against you. You have a right to see witness statements, your statements, police reports, lab reports. You have a right to see photos, video recordings, listen to audio recordings, and see any kind of documents or instruments that the state may have that they'll be using in your case. You also have a right to waive or give up that right as well. Now, everyone that's here today, you're here because you're out on bond. And that simply means that you were arrested, placed in the county jail, and you're out on bond. You're out on bond on a cash bond, which means you paid the full amount of the bond to get out. Surety bond, which means you paid a percentage of the bond to a bondsman. or you're out on what is called a PR or a personal recognizance bond, which means that you did not have to pay any money to get out of jail. You were released under your own personal recognizance. Now, every day that you spent in jail can be used as credit towards your punishment. So, for example, now, notice I said every day that you spent in jail can be used as credit towards your punishment. So let's say you were arrested, you booked into jail at 11:59 p.m. that night, and you bonded out of jail at 12:01 in the morning, 2 minutes later. That's 2 different days. You get credit for 2 days. Don't have to be 24 hours, okay? It's 2 different days. That's how it works. Now, if let's say you and the state have worked out a plea bargain agreement, you spent 5 days in jail, the state is offering you 5 days in jail to serve. That means you don't have to serve any time in jail because you've already served 5 days in jail. Therefore, you'll be given credit for the time that you've already served. Now, if they offered 7 days in jail, you spent 5 days in jail, that means you'd have to do 2 days in jail because you already have 5. You take 5 from the 7 and leaves 2. Now, every day that you spent in jail can also be used as credit towards your fine and court costs. So if you you get $100 per day. So if you spent 5 days in jail, that's $500 that you have credited towards your fine and court costs. So if the state is offering you fine and court costs of $500, you won't have to pay anything because you've already spent 5 days in jail and you have $500 credit. So it'll be taxed and retired. Now, if the state is offering fine and court costs of $700 and you spend 5 days in jail, which is $500, that means you have to pay $200 because we'll subtract the 500 from the 700 and that leaves 2. Now, you'll be required to pay that money on the day that you take care of the case. Now, if you cannot pay it, then we could put you on a payment plan. You can pay so much a month until it's paid off. Now, if you are unemployed and do not have an income, no problem, because we can convert your fine and court costs to community service. You receive $12.50 that will be credited toward your fine and court costs for every 1 hour of community service that you perform. So if you perform 8 hours of community service in one day, that's $100 that will be credited toward your fine and court costs. And so in the scenario that I gave earlier, if you owe $200, that means you would have to work 2 8-hour days, and you will have paid off your fine and court costs of $200. All right. Now, if you've never been in trouble before, first time here, never been in trouble, the district attorney's office has a program that's called pretrial diversion. Well, they will dismiss your case, and you can get it wiped off your record like it never happened. We call that expunge. Now, you can get it expunged, deleted, or wiped off or erased from the record. Now, in order to get in the program, 3 things has to happen. 1, it has to be your first time getting into trouble. 2, it cannot be for an offense involving unlawfully carrying a weapon or resisting arrest. And 3, you have to have an attorney to assist you at making out and submitting the application. Now, I recently found out that the district attorney's office has changed some of their policies. And some of the stuff that I'm saying is I may have to update it. I understand that they just changed their policy regarding the pretrial diversion. But if you're interested, if you think you may qualify, just let us know, and we'll let you know whether or not you can qualify for pretrial diversion. Now, the other thing is, if you're a veteran of any one of the branches of the United States military, Jefferson County District Attorney's Office has another program that is called Veterans Court. It's for veterans only. And in order to get into that program, you have to be a veteran of any one of the branches of the United States military. And the way that works is if you get into the program, you complete the program, the case will be dismissed and you can get it, or what we call a non-disclosure. A non-disclosure basically means that your record is sealed to the general public. Okay? It's sealed where they can't get into it. Now, notice I use the term general public because there's a statute that allows governmental agencies to have access, but not the general public. Now, this court has a program that is called a pretrial, that is called a CSI program. CSI acronym stands for Community Safety Initiative. It's a program that I started within the first 100 days of taking office in March of 2017. With that program is designed to address the issue of what we call recidivism. And recidivism basically means that people commit crimes over and over. And so the way we address that is through our community safety initiative. Now we have partnerships with local agencies. One of the agencies that we have a partnership with is the Spindletop Center. Spindletop is our regional mental health center in Southeast Texas. Now with Spindletop has the expertise to address individuals' mental health needs. Now, they're going to come to you and tell you more about the program in a few minutes. But basically, what Spindletop will do, they can conduct what is called a private interview, either here at our jury room or at their facilities, or even by telephone, whichever is convenient for you. They also have the ability to do an assessment. They have the ability to develop treatment plans for either outpatient or inpatient. Now, you do not have to be incompetent or insane to participate in the program. You can merely suffer from depression or anxiety or any other host of mental illness. Spindletop has the ability, the expertise to address your mental health needs. Now, if you have issues with drugs or alcohol, Spindletop has a program that is called ATAR. ATAR is an acronym that stands for addiction. It's ATAR, addiction, treatment, and recovery. With that, and also we have a partnership with our local drug and alcohol council that has a program that is called OSAR. OSAR is an acronym, OSAR, that stands for Outreach, Screening, Assessment, and Referral. With that program, they have the ability to address issues that you may have with alcohol or drugs. Now, if you're unemployed, that is, you're unemployed or you're looking for a better job, we have a partnership with our Golden Triangle Empowerment Center that has a partnership with Lamar University. And Lamar University has a program that is called CICE. It's an acronym. It stands for Center for Innovation, Commercialization, and Entrepreneurship. It is a job training and a job placement program in the hotel industry, the shipping industry, and the chemical industry. Once you're trained in any one of those areas that you select, then they will assist you at getting a job in the area that you're trained in. If you have not finished high school or haven't received your GED, CICE also has a program, it's a GED program where you can get your graduate equivalency diploma. Now, all of these programs that I just mentioned are free. It does not cost you anything but time. And I like to say in this court, we don't just give time, we take out time. That is, we do not just arrest the problem, we address the problem. And we believe that if we address the problem, we can produce productive people, because productive people will not commit crimes because they have too much to lose. And so I like to say, when you come to county court at law number 2, We do not have court as usual, we have unusual court. It's not because we're different, but it's because we're trying to make a difference in the lives of the individuals that come before this court. And if we make a difference in their life, we'll make a difference in their home. If we make a difference in their home, we'll also make a difference in their community because what comes out of the home goes into the community. So if you're interested in any one of these programs, just let us know, and we're happy to direct you to the people that you need to talk to get into any one of these programs. The other thing is, all of these programs that I mentioned can also be used as community service. So for example, let's say you ordered to pay community service and then ordered to perform community service because you could not pay your fine and you want to do community service to pay your fine. Let's say while you're working on your GED or your mental health program or in the drug alcohol counseling program, the GED program, job training, job placement program, every 1 hour that you're in that program, $1.50 is going towards your fine and court costs. 1 hour is going toward community service. So you're not just killing 2 birds with one stone, you're killing 3 birds with one stone. That is, you're in the program, I mean, you're doing community service, and you're paying your fine and court costs just by doing one thing. Okay. So as I mentioned to you earlier, we have some folks here from Spindletop, and they're going to come to you right now and tell you more about the Spindletop program.
Thank you, Your Honor.
You're welcome.
Good morning. My name is Steve Nitt. I'm a mental health deputy licensed by the state commission here with the sheriff's office. This is my coworker, Holmes. Holmes is a qualified professional. The reason we are both here this morning in this courtroom is because the judge cares about every single person who comes to the bench. The judge found once statistics prove that those who have legal issues commonly have.
What they mean by this is there's a lot of mental health needs such as depression, anxiety, and a plethora of many more that individuals can go through just going through the whole court system as a whole. And also there's a lot of funds that are programs that are well funded but not well advertised that we can assist you with connecting with.
Whether this is your first time to be in court, it could be your 10th time to be in court, there's still hope. In fact, what we're offering you today has the ability to change your life. We're gonna need something from you. We need you to share that need with us. And Chloe will explain exactly how you can do that very quietly.
So when everyone walked in, I gave each one of you a form. It's a resource connection form. If you guys can just fill it out and put your contact information on it, there's 3 boxes. I can call, text, or meet with you guys today in person if y'all want to discuss y'all's needs and just discuss mental health as a whole.
I also have a business card here that I want to give everyone before you leave here today. It has a 1-800 number on there. Should you ever find yourself in an unsafe place, you can call that number and get help immediately. And that's one of the first things we can get you. Now, just shortly, the court is going to go into recess. When it does, we'll be able to come out there. We'll visit with you. I will answer any questions. We'll pick up those documents from you. We handle this out to you. Thank you very much. Thank you, Your Honor.
Okay, thank you, Deputy Henry and Chloe. So, ladies and gentlemen, we're gonna be going into a break in a few minutes. Now, before we go into the break, I need to give you some instructions. The paperwork that you have in your hand, those of you who are here for arraignment, we're going to pick that paperwork up from you. If you need help or assistance at filling out the paperwork, just let us know by simply raising your hand, and we'll have someone from our court personnel to assist you at filling the paperwork out. Now, it's going to take us some time to pick the paperwork up and then evaluate it. And in the meantime, if you need to use the restroom, we have some restrooms out in the hall. The men's restroom is in front of County Court at Law number 3, which is right next door to us. And the women's restroom is on the opposite side of the hall, in front of the 172nd District Court. Now, please do not leave the courthouse Because if you leave the courthouse and if your name is called and you do not answer, your bond can be forfeited. And if your bond is forfeited, a warrant will be issued for your arrest. Okay? So, as I mentioned earlier, if you need some help with the paperwork, just simply raise your hand. We have our court personnel who will be happy to help you. And at this time, the court will be in recess.
Help raise hand.
For the record, your name is Xavier Clayton. Mr. Clayton, would you please raise your right hand? Mr. Clayton, I have before me a document started judge explanation of rights to defendants without attorney. You recognize this document?
Yes, sir.
Is this your signature on the line as started defendant?
Yes, sir.
Or these your initials on the state you would like to apply for a court that you would like to have your case reset to hire your own attorney?
Yes, sir.
Now, Mr. Clayton, before you sign and initial the document, did you read it? Did you read the document?
Yes, sir.
Did you understand what you read?
Yes, sir.
Is everything in this document true and correct? The best you know. Okay, Mr. Clayton, your case is gonna be reset. Sit in that first chair on the wall. Once your case is reset, you're free to go and you have a blessed day. Please raise your right hand. Do you swear or affirm to tell the truth, the whole truth, nothing but the truth, so help you God?
Yes, sir.
You may put your hand down. How are you doing?
Good, are you?
I'm doing fine, thanks for asking. Now, Ms. Gannett, I have before me document.
Yes, sir.
Do you recognize this document?
Yes, sir.
Is this your signature on the line that started defendant?
Yes, sir.
Or are these your initials on the line? Okay. Now, before you sign this document, did you read it?
Yes, sir.
You understand it?
Yes, sir.
Is everything in this document true and correct?
Yes, sir.
Okay. Your case is gonna be reset. Have a seat in that first chair. Wait for her to call you in. You're free to go. You have a blessed day. Cameron Smith.
Morning, Ron.
Good morning. You please raise your right hand. Do you swear or affirm to tell the truth, the whole truth, nothing but the truth?
Yes.
So be called. You may put your hand down. Do you recognize this document?
Yes, Your Honor.
Is this your signature on the line that started defendant?
Yes, Your Honor.
And all these initials that you like to reset to hire your own attorney?
Yes, Your Honor.
Is everything in this document true and correct?
Yes, Your Honor.
Okay. Your case is gonna be reset to give you time to hire a lawyer. Have a seat in that third chair.
Thank you, Your Honor.
You're welcome.
Well.
Was that Mr. Smith? Mr. Smith?
Yes.
Cameron Smith?
Yes.
Have me come in. Need to give him some bond conditions.
Morning.
You're ready.
You already did.
No, you're fine. He's about to give you a bond condition.
And I showed you.
So we're gonna go over right there.
This is Smith. Do you see the document titled Standard Bond Conditions and County Court Law Number 2?
Yes.
I'm gonna go over this document with you. Following the return of the criminal information in County Court Law Number 2, all bail bonds executed for release of any defendant named herein or ordered subject to the additional condition number 1. Defendant shall commit no offense against the laws of this state, any other state, or the United States. Do you understand that condition?
Yes, Your Honor.
Condition number two, defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to test for drugs and alcohol when directed to do so by the court, or B, submit to test for drugs and alcohol, and the test indicates the presence of drugs and alcohol in the defendant's body. Do you understand that condition?
Yes, Your Honor.
And condition number three, defendant shall not communicate either directly or indirectly with the alleged victim of the pending offense, and the defendant shall not go near any residence, school, or other location frequented by the alleged victim. Do you understand that condition?
Yes, Your Honor.
Condition four does not apply. Condition number five does apply. It states that the defendant is prohibited from possessing a firearm or ammunition unless the defendant is a peace officer defined by the section 107
I'm just Superman.
of the penal code, actively engaged in employment as a sworn full-time paid employee of the state agency
Superman.
or political subdivision. Do you understand that?
Yes, Your Honor. I do have a question about number three.
But I am.
So it says that I shall not communicate either directly or indirectly with the alleged victim of the appendix offense. With that one being my wife, and with that one being my wife, and
Mr. Broussard, clause number 23 CCCR 0742. And clause number 24 CCCR 1314. Both cases, Styles Zachary P. Broussard, Mr. Broussard, that's your full name.
Yes, sir.
Will you raise your right hand? Swear firm to tell the truth, the whole truth, nothing but the truth, self you. God.
Yes, sir.
You can put your hand down. Huh? I'm doing fine. You represented by, oh, Provo, Ms. Provo. How are you doing? You waive a record in Mr. Broussard's case?
Yes, we do.
And the state is represented by Andrew Hubel. Mr. Hubel, how are you doing?
Doing well, Judge, and yourself?
I'm doing fine, thanks, Rex. Now, Mr. Broussard,
Yes.
I have before me a document that's titled Information, which was filed by the Jefferson County District Attorney's Office. In this information, it alleges that you, Zachary P. Broussard, on or about March 8 of 2023, committed to Class B misdemeanor offensive possession of marijuana. You understand what you've been charged with? To this charge, how you plead? Guilty, not guilty, say guilty? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you are guilty? Yeah, okay. Now, I also have a document that's titled Misdemeanor Plea Admonishments. Also labeled as State's Exhibit Number 1. You recognize this document? Are these your initials
Yes, sir.
on the line side of it? And is this your signature? That's your signature, ZB?
Yes, sir.
Okay. And on the next document, charcoal certification, you recognize this document?
Yes, sir.
And is this your signature?
Yes, sir.
At the top of this document, it states that this is a plea bargain case, you have no right to appeal. Do you understand that statement? Second box says check states that you're waiving your right to appeal, which means you're giving up the right to appeal. Do you understand that statement?
Yes.
I also have a document, discovery certification. Recognize this document? Is this your signature? Before you sign and initial these documents, did your attorney go over these documents with you? Did you understand everything she went over? Is everything true and correct to the best of your knowledge?
Yes, sir.
Are you a citizen of the United States?
Yes, sir.
Zero for 6-1.
No, sir.
State's Exhibit Number 1 will be admitted. Ms. Provo, is there any evidence that your client is currently mentally incompetent to stand trial?
No, nothing else.
Mr. Broussard, are you satisfied with your attorney?
Yes, sir.
Okay, Mr. Broussard, I'll accept your plea of guilty. I'll find that you're mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, your plea bargain agreement?
We do, Your Honor.
And what's the agreement?
The agreement is to 90 days probated over 15 months with a $500 fine, 60 hours community service, and dismissal of the UCW for forfeiture.
What's his court cost? Okay, let me do this. I need to make some adjustments. Motion of forfeit. And cause number 23CCCR 1259. The attorney go over this document with you? And is this your signature? And you want the court to grant this motion? Okay. Okay. Court will grant the motion to forfeit the weapon to Fort Naples Police Department. Mr. Gomez, you understand the state's offer?
Yes.
You think it's fair, Jess? And do you accept? Okay, I'll follow plea bargain agreement that you have entered into with the state. Please stand in front of the coordinator and follow the bailiff's direction. Once you finish following, you're free to go. Mr. Patch, you also free to go and you have a blessed day.
Thank you, Your Honor. Hope you're feeling better.
Thank you.
I'll be praying.
And are you pleading no contest because you do not wish to fight a contested charge? I have before me on paper. Hold on a minute. Favorite of counsel for first and just put in another one is Jefferson County Judge's explanation. Before signing the initial, did you read these documents? Did you understand what's read? Is everything true and correct? Okay. Also have on the tablet, State's Exhibit number 1. This is mean the plea admonishments. And do you recognize this document?
Yes,
Are these your initials on page 2?
Yes.
Or just your signature on page 3? I also have judge trial court certification, the defendant's right of appeal. You recognize this document?
yes,
Is this your signature?
yes, sir.
At the top of this document, there are 2 boxes checked. The first box says check states that this is a plea bargain case. And you have no right of appeal. Do you understand that?
Yes,
Second box says check states that you're waiving your right to an appeal, which means you're giving up your right to appeal. Do you understand that statement? Give me her paperwork. Now. Give me her paperwork.
Okay.
Before you sign all these documents, did you read the documents? Understand what you read?
Yes,
Everything correct?
yes,
Or you're a citizen of the United States?
State upper states one.
States offering states, oops. state is often states one to be used as evidence in your case. That's the first document that we went over. Is it all right for the state to use this document? No objection. States one is admitted. Ms. Mitchell, I will accept your plea of no contest. I will find that you're, well, let me ask you this here. Mitchell. Is there any evidence that you are mentally incompetent to stand trial? You understand what's going on? Do you have any mental issues that affect your ability to
No,
understand? So you understand, okay,
yes, I understand.
that was my question. Okay. Ms. Mitchell. I'll accept your plea of no contest. I will find that you're mentally competent to stand trial. I will also find that your plea waiver was freely voluntarily given. I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. Thank you. Will be bargain agreements.
We do, Your Honor. In exchange for defendant's plea, the state's offering 1 year deferred, $250 fine, 40 hours community service, theft class plus court cost.
Mitchell, the state is offering that you serve 1 year deferred adjudicated probation. During the 1 year probationary period, you'll be required to pay a fine of $250 plus court costs of $277, plus a probation fee of $6 a month, for your license fee of $15 a month, and reimbursement of $15. Total monthly installments is $131 a month. Are you able to pay the $131 a month?
Yes, but could I get it converted to community service hours?
Is everything on this document true and correct to the best of your knowledge? Okay. The court is gonna find that you're indigent. Let me do this. I need to refigure. Okay, Ms. Mitchell. Your, the court is going to convert your fine and court costs to 42 hours of community service. The probation fee will be reduced to the statutory minimum, 25 a month. You'll be required to pay the probation, reimbursement fee of $15 and the urinalysis fee of $15 a month. Your total monthly installments is $45 a month. Will you be able to pay the 45 a month? All right. You'll also be, you'll also be required to perform 40 hours of community service. That 40 hours will be combined with the 42, which comes to a total of 82 hours of community service. You understand that?
Yeah.
And you will have to take deaf class and adhere to the other standard terms and conditions of this probation. And the court is finding you injured. And the court is making these conversions based on Article 42.15, Texas Code of Criminal Procedure. Okay. Just have a seat. She meant she needs to make the changes on the paper. Paulina Alvarez. Swear to tell the truth, the whole truth, and nothing but the truth, so help you God? You may put your head down. How are you doing? I'm doing all right. Ms. Alvarez, do you waive, you have a right to have a record, do you waive a record in this case? Okay. You have her, paperwork? Yeah, I got it.
So,
Ms. Alvarez, I have two documents. First document is judge's explanation of rights to defense while attorney. Second document is waiver of counsel for purposes of entering guilty plea proceeding the trial. Do you recognize these documents? Now, before you sign the initial documents, did you read the documents?
Yes,
Do you understand what you read?
Mm.
Everything in these documents true and correct to the best of your knowledge.
yes.
I have a document on my computer titled the information sheet. This information sheet alleges
I'm sorry.
how do you plead guilty, not guilty, no contest.
Your Honor. I mentioned something.
Oh. Is it about the case?
Yeah. It was
Well,
pretty serious.
On States one, are these your initials on page two?
Yes.
And your signature on page three?
Yes.
Is this your signature on the charcoal certification?
Yes.
At the top, there's two boxes checked. The first box states that this is a plea bargain case, and you have no right of appeal. Do you understand that statement? Second box check states that you're waiving your right to appeal, which means you're giving up your right to an appeal. Do you understand that statement?
Yes.
Now, Ms. Alvarez, before you signed all of the documents that I showed you, did you read it? Understand what you read? Everything in these documents true and correct? Ms. Alvarez, are you a citizen of the United States?
Yes.
State?
Stay up for States 1.
Okay, no objection. State's exhibit number 1 will be admitted. Ms. Alvarez, is there any evidence that you are currently mentally incompetent to stand trial? Is there any evidence that you're mentally incompetent to stand trial? You understand what's going on today with your case? That you entered a
Yes, I understand.
Okay. State. Like to offer state's exhibit number 1.
Yes, Your Honor.
Okay, the state is offering state's exhibit number 1 in evidence. State's number 1 is the document that you acknowledge to have your initials on page 2 and your signature on page 3. Is it all right for the state to use this document as evidence in your case? Ms. Alvarez, I will accept your plea guilty. Did you plead guilty or no contest?
Papers with no no content.
You pleaded no contest.
Yeah.
Okay. Now, I'm going to accept your plea of no contest. I will find that you're mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
We do, Your Honor.
And what's the agreement?
For defendant's plea of no contest, the state has offered 9 months deferred probation with a $250 fine and 40 hours community service. The 3 days that the defendant has spent in jail are being assessed towards the fine and court costs in this case.
you're gonna be given a 1 day credit for the time that you spent in jail. And so that means that your uh, probation, your monthly installments, instead of being $172 a month, it'll be $163 a month. Will you be able to pay the 163?
Yeah.
Okay. And now, you'll also be required to install an interlock device on the vehicle that you own and operate, finish completely done education class, have an alcohol assessment, and adhere to the other standard terms and conditions of probation. And you'll also be required to pay a DWI education initial evaluation fee of $50, of $150 on the day of the plea. Should a further evaluation be needed, you'll be required to pay an additional $50. Now, do you understand the state's offer?
Good.
You think it's fair and just? And do you accept it?
Yeah.
Okay, I'll follow the pre-bargain agreement that you have entered into with the state. Please have a seat. Okay, who's next? And we're gonna dismiss the other case in this, the companion case, cause number 24 CCCR 167679 will be, excuse me, cause number 24 CCCR 1622 will be dismissed.
And that's, we have that motion before for sure.
And for forfeiture of the weapon, would you please come back up on that case? I have before me a motion to forfeit the weapon and cause number 24 CCCR 1622. You recognize this document?
Yeah.
And is this your signature on the line that's titled defendant? Before you sign and initial this document, before you sign this document, did you read it?
Yeah.
Did you understand what you read?
Yeah.
And is everything in this document true and correct to the best of your knowledge?
Yeah.
And you want the court to grant this motion?
Yes.
The court is forfeiting the weapon, in this case, to the Department of Public Safety. Okay, and the case will be dismissed. I'm dismissing the case right now.
You can have a seat. You'll get your time.
Next one, Jocelyn Olandra Lopez. It's coming right now. The full name is Jocelyn Olandra Lopez.
Yes, sir.
Please raise your right hand. You swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
You may put your hand down. How are you doing, Ms. Lopez? I'm doing fine, thanks, sir. Ms. Lopez, where's her paperwork? Okay, Ms. Lopez, I have before me two documents. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. And the second document is titled Waiver of Counsel for Purposes of Entering Guilty Plea Proceeding in Trial. You recognize these documents?
Yes, sir.
And before you sign any and initial these documents, did you read the documents?
Yes, sir.
Did you understand what you read?
Yes, sir.
And is everything in these documents true and correct
Yes,
to the best of your knowledge? Ms. Lopez, I also have before me a document that on my computer that's titled Information. This information is filed by the Jefferson County District Attorney's Office. In this information, come on, it alleges that you, Jocelyn Alondra Lopez, on or about January 25th, 2024, that you committed the Class A misdemeanor offense of assault by family violence. Do you understand what you've been charged with?
Yes, sir.
And to this charge, how do you plead guilty? Not guilty, no contest.
No problem.
Or you pleading no contest freely and voluntarily?
Yes.
And are you pleading no contest because you do not wish to fight or contest the charges?
Yes.
Ms. Lopez, I also have before me a document that's titled misdemeanor plea admonishment. You recognize this document? Page 2, there are 2 sets of initials. You place your initials on this document?
Yes,
On page 3, there's a signature. Is this your signature?
yes,
And on the next document, child court certification defendant's right of appeal, you recognize this document.
yes, sir.
And is this your signature?
Yes, sir.
At the top of this document, there are 2 boxes checked. The first box states that this is a plea bargain case. You have no right to appeal. Do you understand that? Second box check states that you're waiving your right to appeal. You understand that?
Yes.
Now, before you sign and initial all the documents that I just showed you, did you read the documents?
Yes, sir.
Did you understand what you read?
Yes.
Is everything true and correct in these
Yes, sir.
documents? Ms. Lopez, are you a citizen of the United States?
Yes, sir.
Silver States 1.
Now, Ms. Lopez, state is offering state's exhibit number 1 to be offered as evidence in your case. That's the same document that I just showed you that have your initials on page 2, signature on page 3. Is it all right for the state to use this document as evidence against you in your case?
Yeah.
Okay, no objections, states 1 is admitted. Ms. Lopez, is there any evidence that you're currently mentally incompetent to stand trial? You understand what's going on?
Yeah.
Do you have any mental problems that affect your ability to understand? Yeah. This court is gonna accept defendant's plea of no contest. We'll find that she's mentally competent to stand trial. We'll also find that the plea waivers is freely and voluntarily given. We'll also find that there is sufficient evidence to find her guilty beyond a state. You have a plea bargain agreement?
We do, Your Honor.
What is it?
The agreement is to 15 months deferred probation with a $500 fine, 8 hours community service, anger management, and no contact with Maria Gomez Camarillo. Excuse me.
Carrillo?
Excuse me, I think it is Carrillo. It's
Carrillo?
not Camarillo, it's Carrillo.
Carrillo?
For today's talk.
Okay. And state will be assessing the 2 days jail credit towards fine and court costs. And I'll make any necessary changes to the paperwork.
Okay. Judge, can you send that back to me?
Okay, hold on a minute.
And you need me to change it. Like, well, yeah, I'll do that right now.
Minutes. Okay. Isn't that a $100 crime fee that she has to pay to a victim assistance?
Yes. Yes.
It's 15 months deferred, and what was the fine, the court cost? Well,
The fine was $500 and the court cost is $277. Thank you.
Get 3 days credit, 2 days credit.
2 days.
Okay. Crime victim restitution fee of $100 to a restitution center in Jefferson County. You'll be required to serve, 15 months deferred adjudication probation. During the 15-month probationary period, you'll be required to pay a fine of $500 plus court costs. Court cost is $277. Pay a crime victims fee center $100. You also pay a $60 a month for probation fee and $15 a month for reimbursement and $15 a month for a urinalysis and the $15 reimbursement fee. Your total monthly installments will be $130 a month. Will you be able to pay the $130 a month? You won't?
So what is you want? So, yeah, this one, I don't think they get something that so it's just how you.
He's scared to go eat. This is good. He's talking about me. I'm talking about.
Yes, well, it's kind of like weaker.
Yeah.
It doesn't influence her in the conversation.
She was loud.
I'm scared to eat.
I don't think.
Exactly.
What?
What are you talking about?
Now she said she's not engaged.
Exactly, there's the relevance.
So it doesn't matter. So I guess that's interesting.
Okay. Okay, Ms. Lopez Stace. Offer that you serve 15 months deferred adjudicated probation during the 15-month probationary period. You're required to pay a fine of $500 plus court costs of $277. You will be given the 1 day credit toward the fine and court costs, which totals $777, so it'll be $677. Fine and court costs, that will be converted to 54 hours of community service. The probation fee will be reduced to the statutory minimum of $25 a month. You'll be required to pay the reimbursement. The reimbursement fee will be waived pursuant to Article 102.081, Texas Code of Criminal Procedure. And your total monthly installments. Let's see.
Judge, I apologize. I was speaking with Mr. Valdez about his case. Was a finding of indigence made in this case?
Yeah,
Okay.
did we find that she was indigent? Do we have no, you know what? Okay, you're right. based on the finding of indigency, the the reimbursement fee of $15 would be waived pursuant to 102.081. And pursuant to Article 4215, the fine and court costs of, will be converted to $54 of community service, because you're getting credit toward $100 for the 1 day. You will be required to pay $100 to crime victims center in Beaumont. You're required to pay the statutory minimum on probation fee of $25 a month. And you also be required to pay the $15 a month for your total monthly installments is $50 a month. Are you able to pay the $50 a month? Okay. Do you understand? You cannot have any contact with Maria Gomez Carrillo. You also required to perform 80 hours of community service in addition to the 54 hours, which comes to a total of 134 hours of community service. Do you understand?
Sure.
All right. And you would be required to adhere to the other standard terms and condition of probation. Now, Miss Lopez, if you successfully complete this probation, this case will be dismissed. It would not result in a conviction on your record. And you may qualify for the undisclosure. You can talk to attorney about the undisclosure. Just have a seat for the court coordinator to draft up the paper.
Excuse me, I have a question. I live in Garland. Is there any way?
Tell the probation officer that, and they're gonna transfer it to,
Okay, thank you.
okay,
State excuse, Your Honor.
yes.
Thank you. Oh, yeah. I have to go meet with an officer right now. Later. I have not had an opportunity.
We could do the bond forfeitures later.
Okay, so,
How many we have?
I think it's three.
I think we can do it.
Okay, just tell them, just go down page 1 and just, who we have.
The one that is, regarding the matter, after a meeting with them.
Who do we have?
I'm getting into, I think on March 8th in the front.
What page?
My page 5.
Who?
Mark Fabian Francois.
Okay, who else?
Dylan Garner, where he fit with his felony.
He's in jail.
He's in jail, okay. David Lindsay.
We just did Lindsay.
Oh, yeah, we did Lindsay. Please. Oh, but I guess did I not do that?
I guess not. Who else?
Wait, another, that's it. And let me make sure he was getting all these bills.
Who?
Francois, because it's an out of county bond. Yes, it says, Nelson, Mickey Robinson. So that will be